really started to heat up. There was the case challenging just the township's authority to enact regulations at all. We lost that one. And then a township attempted to regulate through zoning. Of course, that was pretty immediately challenged. That went to court and was ultimately upheld. But then there were challenges on interim ordinances and whether those were valid and whether you had to go through a normal ordinance adoption procedure in order to adopt them. So that's been challenged. And then after that, there's been any number of challenges related to whether the ordinance was properly drafted, if it's too broad, if it's been applied properly, if in approving or denying something you've acted arbitrarily, capriciously. So yes, I mean, if you get involved in zoning, you can be challenged anywhere from the procedures you use to adopt it, the validity of the language of the ordinance itself, all the way to how it's been applied and enforced. So yeah, I mean, that's just all part of the package. When you get into this, you're subject to challenge for any number of things.
Are many of the challenges successful on other than procedural matters?
Not the authority piece of it. You know, the authority is pretty well established now. I think that the two bigger areas of risk for towns are the drafting. Frankly, there's still towns out there that will take off one town's name and just throw their name on the top and say good enough and adopt it, and without really examining, without really having a lawyer involved. Not that having a lawyer involved is an absolute guarantee that you won't get challenged or even lose, but you're much less likely if you have some professional drafted for you. And then the other area is just in the administration and enforcement. Because frankly, if you set it up for a conditional use permit and you don't follow the process right, or you don't make sufficient findings to support your decision, that's a pretty fertile area for challenge, whether it's feedlots or anything else for that matter. Like anything else, if you don't follow the procedures properly or have a decent, a legitimate basis for the decisions you're making, then the courts aren't all that sympathetic. They'll blow you out of the water because they really view this as you've adopted a law. In some cases, through the zoning, you're sitting like judges. They call it quasi-judicial decision-making. And if you don't do a good job on that and explain yourself in writing, follow all the statutes, then they're not hesitant at all to say your decision was invalid and throw it out.
Based on a lot of the research that the townships have, the committees have turned up over the last year, for example, Spring Creek Township wrote in that they would like to limit feedlot size in their township to no more than 300 animal units. In your opinion, is that legally defensible, and or could that be challenged in court? And do you have an opinion if it would be successful, the challenge?
Yeah, the animal unit limit, I think you can do that. You know, there's some towns that there really isn't much agriculture left in them. And so the idea of limiting the size or maybe even outright prohibiting it is going to depend on the nature of your community. The 300 animal unit, my argument would be if they properly adopted it and they had a rationale findings to support that animal unit cap, then it should be defensible. You know, frankly, the thing is when a town board sits and makes these policy decisions, courts are not supposed to overturn a policy decision. You know, as long as it's supported in law, that's your decision. That's the whole separation between the branches of government. When you're drafting and adopting ordinances like this, you're acting in a legislative capacity, and of course the courts are judicial, and so they're not supposed to try to supplant your legislative decision making with their judicial decision making. So they're supposed to leave that alone. Now, there's any number of scenarios where you could run into troubles on something like that if it's not properly supported. So an animal unit cap generally should be defensible if it's done right, and you have good findings to support why you're coming up with whatever number that is.
The same township, also based on the health research that's been conducted, would like to set a 1 mile setback between all feedlots and all residences, and a 1 mile setback between each feedlot. In your opinion, is that legally defensible, and would that hold up in court if challenged?
Well, I can tell you the Department of Agriculture years ago required or got some legislation passed requiring that all communities submit their feedlot ordinances to the state. It's actually still on the books. And part of the reason they were doing that is because they were then taking that information, setback information particularly, and running studies where and I've seen these maps, they would throw out a map of Norman County or whatever and say, okay, in this township, they have a half mile or mile setback, and then they would do, the circles around each of the feedlots and homes in the county and say that essentially you've zoned out feedlots. So you have to be a little bit careful with getting overly aggressive with the setback distances. I'm not saying that in some situations I'm not saying a mile is on its face invalid and would be overturned, but if it's just a mile period for all feedlots, I don't care if you have 10 animal units or 1,000 animal units, I think that runs the risk of being deemed arbitrary just because there's really no rationale behind it other than we don't, it would be cast as we don't like these, and so we're trying to figure out a way to zone them out. Because 1 mile, I mean, really, if you did that and drew those circles, I suspect there'd be very little area left in the town to allow for either a new home or a new feedlot.
Are you aware of townships or counties that have had setback ordinances challenged and defeated on that basis?
Not that I can think of off the top of my head. Certainly, though, I mean, the setbacks have been an area of controversy for many years. So I don't know if, again, I didn't do a bunch of searches on that. I mean, I certainly could look at the case law and see if there's been anything on setbacks. I just haven't done that study or that research recently. None come to mind, but that's not to say I don't think that's all decisions related to feedlots are necessarily bulletproof. Again, I think you have to have some rationale to it. Like, for instance, if you're looking at setbacks, having a setback based on the size of the animal feedlot rather than just across the board. If you're a feedlot, then it's X. I think if it's a feedlot between this size and this size, then it might be this number. If you're between these these numbers, and it's a little bit larger. I mean, that brings more kind of reason to it to say that, the presumption is larger animal feedlots are going to create more of the stuff that we don't like to live next to, the noises and the smells and carcasses and all that. And so then legitimately we want that pushed further away from residences. So I mean, I think that sort of scheme would be more defensible than just a flat setback.
Can township residents, electors, vote directly for or against township ordinances?
Do you mean specifically on feedlots?
Yes, for example, if a township board wished to draft a feedlot ordinance, is there a mechanism by which the township electors could vote directly on the ordinance rather than having the board members themselves vote yea or nay on the ordinance?
Well, I have to give you a little bit of a talk about how township zoning authority is set up. There's actually two different sets of authority for town zoning. One is chapter 366, and it's been on the books for decades. I don't recommend that any township rely on it, but it's been there for a long time, and like a lot of old township law, it requires elector authorization in order to start it. So in other words, there would be a question, you know, shall the township engage in zoning? And the people would vote on that, and if they vote yes, then you're empowered to move forward with zoning. They don't vote after that, they don't vote on this ordinance versus that ordinance, it's just more the authority of whether or not you get involved in zoning. In about 1983, the law was amended to allow all townships to zone through chapter 462, which was prior to that exclusive to cities and certain urban towns. But in 83, 84, that was opened up to all towns. And under that scenario, you're automatically given the authority to zone, so you don't have to go to the electors for a vote. And the electors certainly don't vote on any of the ordinances that you would adopt under that authority. So regardless of the authority, they don't vote on individual ordinances. That's left entirely to the board. And like I said, if you guys are thinking of zoning, don't even look at chapter 366. Frankly, antiquated. It's not something you want to rely on. You'd be looking at a 462 for the authority.
Can township residents sue their township board and township board members for actions the majority consider arbitrary and capricious?
Now, for the most part, no. You know, there's been we don't like it, but you have to have standing to challenge something to bring a lawsuit. And so typically this sort of general citizen suit, for the most part, only comes about if there's some sort of, as a taxpayer action, they think you're wasting funds or something like that. That doesn't happen very often, frankly. Really, the reality of it, it's a political question. If a bunch of people don't like what you're doing on the board, there's an election. I mean, that's really how that's handled. There really isn't much liability exposure from the sense that if I do a good job, you know, we get the help necessary to draft a good ordinance, even though people may disagree with it, one way or the other. We went through the right process, we got help, you know, and we followed all the steps and we adopted properly. There's really no personal liability risk there. Again, there may be political pressure and you may be voted out of office eventually, but your personal exposure is not great at all. And in fact, the township has to indemnify you. So sometimes what you'll see is someone who really gets mad about an ordinance, so they'll sue the township, and then they'll start naming individual members of the town board. So we sue XYZ Township and Supervisor Joe and Supervisor Bob and Supervisor whatever, and maybe even planning commission members. The reality is all those folks are indemnified by the town, so you get defended through the township association if you have their insurance. And it's not like your farm or your business is on the hook on something like that. That's assuming you're following the law and you're doing everything right. If you go out there, I had one guy who went out and took town equipment and tore up some guy's yard, well, you're on your own then. I mean, you know, you acted individually, you acted criminally, then you're on your own. But I mean, if you're just making a valid policy decision, yeah, I mean, realistically, you're not getting in trouble for that. There's no real personal liability there.
Speaking of personal actions and tearing things up, is there anybody have anything that they want to bring up about actions that have occurred in the community?
You can see that sign.
That's something you might want to look at here. The camera is right there. Keep close to it. Can you see that?
I can see there's writing, I can't really read it. Rodney, you leave county ordinance alone, otherwise you will be taken to court for township paying for your basement and gravel for your yard. Okay.
Propped up against the township board member's mailbox post one night.
Okay.
As an attorney, would you have any recommendations on any actions or considerations that might result in such actions?
Which actions? Putting the board up or using town resource for basement?
The former.
Well, I mean, you certainly could contact the sheriff's department and let the deputies know about, you know, this is, you know, just what happened, just so there's some report of it in case there's other incidences. You know, maybe it's not a board against the mailbox, maybe the mailbox is in the ditch or something. You know, if it escalates, it's good to create a record in the police department about the incidences you've encountered. But other than that, I don't know what else you could do, frankly. If the second part of that is true, well then there's a, town resources were absconded with and used for personal purposes. We all know that's wrong, and of course you can get in trouble for that. So.
It wasn't done though.
Well, no, and I'm not saying it is, but I mean that's the kind of stuff that you encounter. I mean, I've worked on power plants going into towns where lawn signs and every nasty thing you can think of being said, and I've worked on zoning ordinances in northern Minnesota where there's so-and-so's a bum, don't go to his store, and he was an appliance salesman, boycotting the stores. I mean, there can be some really, and signs going up, and I can tell you, the answer on most of that is people saying bad things about you when you're sitting in public office. That's all part of free speech, and even though it hurts you personally, kind of emotionally, may even hurt your business, tough, the law doesn't really protect that. When you're in the public eye, that's why we can say nasty things about politicians.
It's been recorded at the sheriff's office, so.
Good, good. And of course, if it's not true, then really there's nothing to worry about. Like I said before, there's no ends of threats. You're going to get sued. You don't have enough, we're going to break the town's back on this. There isn't enough money in the world to pay for all the damages you're going to end up having to pay and all that. I mean, the reality is, yes, lawsuits can be brought. Rarely have I seen damages brought against towns, at least so if you do get sued, again, this is assuming you do things right. I mean, if you take away nothing at all, if you take away one thing from tonight's talk, and believe me, this isn't a self-promotion, you've got to do it right. That's the times I've seen townships get really raked across the coals. If they just try to wing this stuff, they throw, we like a little bit of this ordinance, a little bit of that ordinance, we'll just, so-and-so's good with the computer, they'll just throw them together in an ordinance and we'll adopt it. That's where you get in trouble. You get blown out of the water. Again, you're not going to personally lose your house or anything over something like that, but those are the cases where you get sued and lose. Because believe me, there's enough potential challenges even if you do it right. But if you're going to do this, it has to be a commitment to not only do the draft the ordinance properly and adopt it properly. It doesn't end there. It's actually administering it properly, because you can get in as much trouble not administering it right as if you adopted a bad ordinance in the first place. So a lot of townships I talked to over the years, how much does it cost to adopt an ordinance? And I said, that's going to pale in comparison to how much it's going to cost to enforce it if you have to. So don't look just at thinking adopting the ordinance is the end-all, of the expense and involvement. You have to look beyond that. Some townships haven't had to enforce an ordinance in 20 years. Others, frankly, 2 months out are enforcing the thing. So it really all depends. But for the most part, if you do it right and you seek help and get help when you need it, even though it seems costly and boy, this is a lot of money, frankly, that's the best way to protect yourselves moving forward. And if you do get sued, the Township Association, if you have insurance through that, what ends up happening is you submit that right away. We'll wait and talk about this at the town board meeting. If you get sued, you have 20 days to respond to it. So you have to get that day or the next day into the Township Association. They'll review it. If there's coverage, which in most of these cases there are, again, unless you're ripping up someone's yard on purpose, then they appoint a defense attorney who will then get in touch with you in pretty short order and start preparing a defense for you. And that comes out of the township's pocket, or excuse me, the insurance pocket, not your pocket. There's some cost share involved, but it's thousands, it's not tens of thousands. And like I said, typically I haven't seen damage awards against townships. You hear that I sue you because I think you did something wrong, and I've been harmed to the tune of $150,000 or $200,000 or something like that. I can't say that it can't happen, but typically in these cases it's more of a question of whether you follow the proper procedures, whether your ordinance is valid, those sorts of things.
Do you know in Minnesota, have any townships or counties been sued by downstream agencies as they have in Iowa for failing to protect the water quality within their jurisdictions, resulting in higher costs downstream? Referencing the case of the City of Des Moines water plant suing two upstream counties for extra costs to treat the water for Des Moines drinking water.
Yeah, no, there's been talk of that. I know there's some concerns, particularly with some of the powers that have been being given to, or are held by various native groups, the different tribes. They're able to set some of their own standards. So there is some risk there, potentially. But I think the risk is relatively small for townships, frankly, because you don't have a duty to protect waters. That's more of a county issue, frankly. So without a duty, there's no way they're gonna say that you're liable because you didn't do enough to protect it. So, again, where counties might arguably have some duty in that respect, townships just don't. And so I wouldn't be concerned about that.
Are you familiar at all with the recent ruling by the North Dakota Supreme Court in the case of Doctor versus Burley County Board of County Commissioners?
Nope.
Okay. They had a ruling, the Burley County Commissioners were asked to rezone an agricultural parcel for industrial uses. Their Planning and Zoning Committee recommended that it not be rezoned. Majority of residents at a public hearing recommended that it not be rezoned. They decided to rezone it anyway, even though the parcel was next to an organic farm. The organic farm owners sued the county for sued the county for arbitrarious and capricious decision. The North Dakota Supreme Court found that it was not, because it upheld the standards of a decision made based on a reasonable interpretation of events. Do you think decisions like that have an effect on the relationship of responsibility to residents between townships and counties going forward?
Well, that decision is consistent with, I think, the way Minnesota would probably decide a case like that, if that helps at all. Rezoning is a policy decision, and again, we get back to that policy versus authority. And with a policy decision, the courts, like I said earlier, are not supposed to substitute their discretion or their decision making for the legislative body. So it's legitimate. Zoning is left not exclusively, but the governing body is the one who decides zoning, what the initial zones are, and whether to rezone. That's not to say there's never been a rezoning that's been overturned, because again, you can be arbitrary in those decision makings. But if you're following proper procedures, you're not spot zoning, you're not doing some of the other no-nos that the courts have said you can't do that are contrary to law. That's decision making. That's what those elected officials get to decide. As far as relationships, that shouldn't harm relationships in the sense that that's the authority. I mean, you may make a decision someone doesn't like, but like I said earlier, that's a political decision. I mean, you deal with that at the ballot box.
The advisory committees have gathered a considerable amount of evidence confirming feedlots' long-term effects on community health and ways of life. How best can this information be utilized to support the ordinances our townships are drafting? Should they be compiled and coordinated as findings of fact?
Yes, yeah, that's definitely it's a good question, and that's all part of what I've been saying about doing it right. Is you gather that information, you cite to it. You have not to bring in an odd issue, but adult uses. This is the same kind of thing that adult uses. They'll pull together the studies of the negative effects of adult uses in certain neighborhoods and next to things, and they pull all that together and say that because of this, and we cite to it all, and we keep a copy of it, because of all this, therefore we're going to enact this regulation. that helps support. Now, of course, the difference is there's a First Amendment protection there, so there's a little bit higher burden on you. But yes, so you would put all that together. I think initially, because you guys are all in interim ordinance stage, that would be made part of the report. We have reviewed the following reports, whatever it is, and you would actually literally list them, cite to their names within your report. Here's the information reviewed. Here are some of the conclusions that we have reached, or findings that we have reached after reviewing that. Therefore, we recommend you do something, do this or that. Because of something we saw here, one of the conclusions is this. In order to address that, we recommend you adopt an ordinance that has a XYZ setback, or that ensures that this issue is protected or addressed. And then that would all help build the record if the township does move forward then and adopt that, some restrictions based on that. All of that helps support what ultimately gets adopted.
Which ones can you use? I guess that's my question, because you can go on the internet and I can find you a whole bunch of information.
Right.
But which ones are legitimate and which ones aren't? Same on both sides of the argument.
Well, of course, there's always there's always two ways to view something, and the more you're dealing with university reports, state reports, like that GEIS I mentioned earlier, those sorts of things, those are all better, if you will, versus a personal rant. If you look back at someone and you realize it's just some guy sitting in his kitchen writing this stuff, that's not going to get you anywhere. But if it's a university professor going through a study through their university, those sorts of things, that's going to be more legitimate. But not always foolproof. It's just one of those things that, and you have to be a little bit careful. Lawyers sometimes fall prey to this too. When sometimes you're looking, sometimes you have a tendency to only pick up on the things that support your position and disregard those that don't. I would encourage you not to do that, and to look at the counter positions, because frankly, that'll just show that you really are doing a study and not just trying to justify something.
That gets us through most of our starter questions, prepared questions. Does anyone else have additional issues that they'd like to bring up for Mr. Gilchrist at this time?
I'd like to ask one. If we were to propose or put forth to, and my position is to try to encourage our county to amend or to modify their ordinance too. If we were to put forth the number 300 animal units, no new feedlot of 300 or more, and also include a 1 mile setback, you think that's a reasonable for a new proposal?
Well, let me answer it this way. I don't know your county board, so I have no idea, but I've been around this issue long enough. I'd be surprised if that gets much traction, frankly. That strikes me as being really restrictive for a county, because you have to, you guys have big enough territories with 36 square miles. They're looking at the entire county. I'd be surprised if something like that gets traction, frankly. But, there's other things you could do. I mean, again, I don't know if anyone in your county has looked at that, Jacobson, I think is his name, with the University of Minnesota down in the cities. He's the one who came up with that way of that smell test, essentially, that nuisance, annoyance level testing. You can find it. They're called nose rangers. They hired a bunch of college kids to go out, stand out in fields and do different gauges of smells and that. Like, for instance, if your county doesn't have that, maybe that's the way to come at it kind of sideways rather than just argue over distances. maybe say, well, maybe we should look at this. And maybe this is a better way to do it rather than just having a straight quarter mile or something like that. That way it's something that's more attuned to the particular situation. So, you know, there's maybe, and I'm not saying that's necessarily the answer in your case, but you might be able to get at least a conversation going versus, I think there should be a mile. That would never pass. You know, or, you know, if we try to adopt that, we're gonna get run out on a rail, that sort of thing. Versus, well, let's have a conversation whether something like this might work, or maybe more of a graduated setback based on size or something like that. So that might be strategically a better way to approach it than just a mile setback.
You're referring to the Minnesota's offset program?
Yes, there you go. I was trying to remember the name of it, right?
We have discussed that at prior meetings.
Okay.
Are there additional questions for Mr. Gilchrist? Comments? Okay. Well, we'd like to thank, any more? Okay, we'd like to thank you very much for your participation this evening. Thank you for your time. Any other words of wisdom based on your vast experience in this field, or for us out here in the boonies, struggling through the wilderness on our own?
Yeah, I mean, it is tough. Whether it's this issue or any number of other ones, I mean, it sounds like, you know, the work that you've been doing is good. You really are doing, it sounds like, a thorough job of it. And what I said earlier about doing it right, that really is, I mean, if that's, I mean, that really is the one thing, if you walk away, that's the thing. Really work to do it right. Because, again, people may take pot shots at you one way or the other on it, but if you're coming from a well-researched, well-reasoned position and you do it right, you get the help you need, it's not a guarantee, but you're going to be in a so much superior position to everything I've seen where some folks just kind of hack through it and don't do a good job. And frankly, and I've told towns this for years, because I was the one at the legislature dealing with these arguments, a town in wherever county would just half-bake something, adopt it, it blows up for whatever reason, it's not a legitimate effort. That gets to the local legislator, that gets to the senator, that gets carried back down to St. Paul and say, townships do not know how to do this, they're botching it, we should get rid of township authority in this field. And we based that years ago, again, back in the late 90s, I think it was, efforts to get rid of township zoning authority, at least with respect to feedlots. It came very close to passing. So, I mean, my point has always been, not only if you don't do it right, not only do you jeopardize your own litigation, which even though it doesn't cost you a lot out of your own pocket, no one wants to go through litigation because it's expensive as far as the human element goes. You're taking off work, you're being deposed by sometimes someone who's not very pleasant on the other side of the table. You're having all these special meetings, you're having to go to court. It's not a fun process to go through, even though it doesn't personally cost you much. You know, why risk that by not doing your best through this process? So do it right, and you should be fine, really, whatever you decide. Even if it's to say, you know what, we're not going to do this, and some people say, well, I'm going to sue you because you didn't adopt an ordinance. Don't worry about that either. That's a policy decision. That's not going anywhere. So if you decide not to do something, that's fine. That's within your authority. If you decide to do something, do it right, and you should be fine.
What's the time frame for basically where we are now, considering, you know, we've got some initial ideas for some ordinances we want to draft. What's the what do you think is a good time frame for getting from here to actually having a township board vote on whether or not to enact an ordinance?
I would say from recommendation, you know, here's our report, and maybe even recommended ordinance or components of an ordinance. I would say you want to give yourself at least 6 months, because Of course, it doesn't take that long, you know, theoretically, but if you're looking at an attorney review, that's going to take, depending on how thorough your ordinance is. I mean, if it's a 5-page ordinance, that's one thing. If it's a 35-page ordinance, that's something else, or a 55-page ordinance. That's going to assume 2 months for attorney review, another month or two for hearing, a planning commission hearing on it, establishing a planning commission, doing the hearing, and then going to the town board. So again, I'd say 6 months. That should give yourselves a little bit of a cushion, but this stuff never goes as smoothly as you think. And then you did remind me of another word of wisdom on this, is that I would recommend that your group not spend a great deal of time trying to draft ordinances. In my experience, I spend more time trying to fix ordinances that are handed to me than if you just tell me what you want and have me draft it for you. Because often there's stuff thrown in there that maybe folks don't know what it means or why it's there, and then I'm answering my head going, do they really mean this? And they really want them to figure this out, you know? I say instead of worrying about instead, maybe pull up components of ordinances that you like. You know, we like this approach to how this is done, and we like that, and we like that. We don't like this, or you know, that sort of thing. And frankly, an ordinance is going to be a page thing. Even if you have relatively regulations, there's still, you have to set an administrative component to it. There's general provisions in the ordinance that have to be in there. So, big thing that I can't figure out for you is what sort of regulations you want. I can tell you how you process the CUP and how you do a variance and an appeal and all those things, all those administrative things, and where your power is and the definitions and all that. What I can never tell what you want is the regulations, you know, that in-between part about what do you want to regulate and how do you want to regulate it. That's the key part that if you want someone like me to help you, that's what I need from you, so I can, again, the administrative stuff is one bookend, the general provisions are the other bookend. It's that middle part, the regulation, that I need to know what you guys want, so then I can craft that into something that works.
Good. Last call? Okay, I think we're done.
All right, thanks everyone.
Yeah,
Yes,
thank you.
Thank you very much for your time, sir. Okay. That was the question and answer portion of the evening. Does anyone have any other business that they would like to present at this time?